Mr. Smith?
May it please the court, my name is Mark Smith. I'm the state appellate defender, and I'm here representing Lavelle McKinley, whose attorneys, the adult public defender office in Des Moines, were disqualified by the trial court prior to trial merely because other attorneys unrelated to this case and that have nothing to do with Mr. McKinley's case had previously represented potential state's witnesses in other unrelated matters. And in doing so, the court abused its discretion. Generally, and this court has said in Bottoms and some other cases that are cited in the brief, that sort of there is a nexus between the Code of Professional Response, or the Rules of Professional Conduct, and whether or not attorneys should be disqualified. And although Judge Gamble at the trial court level recognized that those rules play a role in this, he just totally misinterpreted what the rules require and what they permit. And I'm talking specifically about Rule 1.9, which talks about what sorts of duties an attorney has to former clients. And I'm presupposing here that whatever duties the specific attorneys in the office had with regard to these prior clients at least is arguably imputed to everybody else in the office. And the real issue is, and the court spends a good deal...
Counsel, on that point, is it your position that we have decided that case, that issue, I mean, that the conflict of one person in the public defender's office is imputed to everybody there?
I don't believe that has been decided. However...
Have we suggested it a time or two, sort of in passing?
Well, the rules themselves with regard to imputing imputes conflicts, unless the conflict is totally personal to an individual attorney in the firm, would impute it to other members of the firm. And I think a reasonable reading of those rules would suggest that each individual public defender office, separate and distinct, is in fact a firm as it might be defined.
There's states that disagree with that. They say that you're covered by what we call 32.111 and not by 32.110 because government officials are different from private law firms. I found a case in the Connecticut Court of Appeals 2011 that basically addressed this issue, the very issue before us, by saying that as long as that other individual in the public defender's office is walled off, you don't impute the conflict to the public defenders that are actually representing the defendant.
And I suppose I would prefer that in the grand scheme of things, but I don't think it makes any difference. First of all, although public defenders are paid by the government, it would be difficult to suggest that we, in fact, are government lawyers. I mean, the government's always on the other side, and we don't represent an agency. And I can understand, for instance, in a prosecutor's office, or the attorney general's office, let's say, if one assistant attorney general might be disqualified from representing the state in a given case, that the whole attorney general's office, I mean, who would do it? It would be like the whole court recusing itself.
The counsel, the government has to provide a lawyer for those that can't afford it. So, I mean, you are paid by the government. Aren't you a little different from a private law firm?
Well, a private attorney that's representing an indigent defendant is paid by the government as well. And so I don't think you need to go there.
But if we do go there and conclude that you do not impute the conflict, then you win, right?
Yes. In fact, we probably win easier than the argument I'm making.
Isn't that a tough argument because when we adopted the model code, we said there's no screening and no Chinese wall. A year later, the ABA changed their model rule and said there is screening. And I think it was because of this problem we're having here and with private law firms. But our court has decided not to adopt that new rule. So aren't we sort of stuck with the no screening rule? I mean, because we didn't go to the ABA way?
Well, yes, but I don't believe that you get to that. You don't get to where you have to have a screen in this particular case. If you take a look at what 1.9 says, and this talks about what duties an individual attorney has to a former client, and that's what we're talking about in this case. And quite frankly, in this case, it's somewhat removed even, because we don't know today whether any of those former clients are ever going to testify at this trial. And clearly, if they don't testify, there can't be any kind of conflict. You know, we don't know what they're going to say. We don't know anything, and neither did the trial judge when he disqualified the whole office. And quite frankly, 1.9 says some hurdles have to be overcome before there's going to be any disqualification. And the first hurdle is the biggest one, and that is this matter the same as the representation of the former client, or is it even substantially related? It's clearly not the same, because none of those former clients was charged with murdering the victim in this particular case. Is it substantially related? No, it isn't. One of the defendants, one of the former clients, potential witnesses, was charged with a drug offense. There's no drugs in this case, as far as we can tell. The other two were charged with misdemeanors. One of them was possession of an unloaded firearm, and quite frankly, this case involves strangulation, so it can't even be the same gun that was involved, which I don't think was actually substantially related anyway. But the issue is, are these matters substantially related? And if they're not substantially related, then there is no grounds for disqualification, because the attorneys, and in this particular case, they're not the same attorneys that represented any of the other three, have no duty to these witnesses, former clients. And even the attorneys that individually represented them before have an unbelievably reduced duty to them. And I think that duty is embodied probably in the use of confidential information portion of Rule 1.9. But even that rule says, well, quite frankly, that rule says it has to be the same matter. The purpose of this rule, and the evil that we're trying to avoid, I think, in this particular case, it's attorneys gathering information about a matter, about a case, and then switching sides. You know, I think one of the cases we cited in the reply brief, I think Killian talked about the conflict inherent in not necessarily switching sides, but I think in that case it was picking sides. Because
If the attorney in your office is basically just using information in the public domain and not using any other information or even know of any other information, how is there the conflict?
there isn't a conflict, and that's the issue. What Judge Gamble found, particularly with regard to the husband of the victim, was that the attorneys in the case would likely use his felony drug conviction for impeachment purposes.
That's a public record,
That's a
though.
public record. That there is no use of anything that even approaches confidential information available about any of these witnesses.
Counsel, and address, if you would, the temporal separation between the public defender's representation of those three potential witnesses and the matter at issue in this case. How remote were those
You know,
instances of rape?
I don't know the answer to that question specifically, other than I do know that with regard to the two misdemeanors, Mr. Manuel, who may or may not be available as a witness, at least at the time of this hearing, he was on the run somewhere, and the neighbor, Ms. Hickman, those cases were over. That's all I'm aware of. Now, I am aware at the time that this case was pending, the husband was on probation for some drug offense. So I assume it might be more recent than the other two, but I do not know the specific dates on which those things occurred. I just know that they were in the past.
In the Smith case, we gave some significant weight to the screening regime that was voluntarily followed by the parish firm. You know, is the separation, is the screening that you're suggesting could happen in this case better or the same or less substantial than was present there?
Well, I believe it's similar with regard to the individual thing with regard to the screen, if that's the case. I do have some concerns about the process that was used in the Smith case. I don't know how you bring in another attorney to cross-examine one witness and make the trial work. I don't know how that works, but I do know that that's what was done in that case. And they did screen off the trial attorney from information about the other client, but they never, that was, as I recall, contemporaneous representation, and that's another thing that differentiates this case from Watson and Smitherman and Smith, and that is, this is not duties to a current client in another matter, which is what those three cases talk about. But this is whatever duties are left over when you're finished representing clients. And the suggestion that the fact that I have in the past represented somebody who's going to be a witness in a trial for a client that I represent right now can somehow veto my ability to represent those people is just almost unfathomable. And that's what Judge Gamble says. Unless those witnesses all consent, you know, there can't be representation. McKinley knows the problem.
But I mean, I gather the concern is, in the past, representation, unrelated representation. You hope that there was candor between the lawyer and the client, and the client may have disclosed all kinds of difficulties. The lawyer's role was just to defend on the particular matter, but is sworn to confidentiality for whatever embarrassing information or impeachment material. There's at least a possibility that someone who had a past representation knows substantial information about that client that was garnered in the attorney-client relationship that, if known in the subsequent case, could be useful. Now, as I understand the record, this is entirely speculative at this point, but I guess I'm probing you. Do you see the problem I'm digging for? And if so, I want you to respond to it.
I see the problem that you're digging for, but I think in this particular case, the specific attorneys that are in this case know nothing about those prior representations other than the fact that they occurred. And so the danger of them acquiring this information, I mean, unless the witness sort of blurts it out in the middle of a deposition or something, they're never going to get that information.
Isn't that the policy reasons why the ABA went to screening? Because in the practical matter, those things happen. But our rules didn't go there, and we haven't updated our rules. So do we just ignore our rule and, in this case, adopt a screening rule contrary to our present rule and consistent with the ABA rule without going through the rulemaking process?
It'd be wonderful if you would do that, but I don't think you have to go there. You don't have to go there because these matters are not related at all, not even tangentially related to one another. And if they are not related, I see my time's up, can I finish? If they're not related to one another, then the issue of confidential information is there has to be some showing that the attorney actually has it, and there isn't any showing here. Thank you.
Thank you very much. Mr. Bueller?
May it please the court. Good morning, Your Honors. My name is Tyler Buller, and I represent the state of Iowa. This case is a little bit unusual for me. I'm going to stand here and actually agree with the appellate defender's office, at least in a narrow sense. The district court record in this case doesn't support the disqualification of the public defender's office. But in the particulars, I think the appellate defender and I part ways. The state really sees this case as an opportunity to clarify our case law and provide some meaningful guidance. Before I move on to the law, Justice Hecht, I want to answer your facts question that you asked. All the representation in this case is between 4 and 7 years old. It's not like there was a brief overlap or anything even close to a brief overlap. The closest would be Mr. Rouse, who was on parole at the time, not actively represented by the public defender's office. In terms of the law, this court should hold that there are two distinct ways or two distinct reasons that can justify the disqualification of counsel even over a defendant's objection. And the first of those is an actual conflict of interest. And the second is representation that would undermine the criminal justice system. The first prong, the actual conflict of interest, has been defined by the United States Supreme Court in McKinley v. Taylor. And their definition is representation that adversely affects the defendant at trial. This court followed that language in Smith and in Smitherman, and we see that this court embraced that concept going as far back as State v. Turner in 1984. Well, Watson kind of took a turn off of that concept, and Your Honors, the state's position is that Watson should stay where it is, buried in the past. I know in Smitherman there was a suggestion that Watson might still be good law, but the problem with a statement like that is that we end up in the situation we're in today. Prosecutors are afraid of that rule. It's sort of hanging over everyone like a ghost. If we don't have this hearing, if we don't move for a so-called Watson hearing, there's this potential for automatic reversal. So I would encourage this court to just disavow that language entirely because it leads to problems. It's ultimately bad law and bad public policy. And we don't have to look any further than what we see in this case. Watson is why the public defender's office was disqualified, because the parties were afraid without a hearing, without this searching analysis, that automatic reversal might happen. The state would lose finality of its convictions and the district court would be reversed. The adverse effect rule, the one that's provided by Mickens, is workable. It provides meaningful guidance and it's easy to assess, even before trial, when representation is likely to adversely affect a defendant. The easy examples would be the contingency fee cases. It's easy to see how if a lawyer's ability to get paid depends on whether his client takes a plea deal, obviously there's a potential for some kind of adverse impact. He might not do what he's supposed to at the trial. And then we also have the sort of stretch your imagination example, the Law and Order TV plot twist where the former client confesses to a crime that the current client's facing at trial. And Justice Apple, I think your question was getting at this is, could there be some information out there that the former client disclosed that somehow affects this trial? Sure, maybe. But in a case like this one, there is no chance of that happening. The public defenders in this case don't have any confidential information. The public defenders told the district court that they would take steps to make sure that they don't acquire any confidential information.
Mr. Buller, go ahead.
But for your argument to work, you have to have screening. And again, our rule 1.10 is not the same as the ABA 1.10, and the court made that conscious decision and hasn't changed it. So how do you get around that? I mean, if we could interpret it, maybe, but you know, we made that conscious decision not to do that, and we had the choice when we adopted the rule. The ABA eventually changed, and we haven't. So how do you get around that?
The easy answer is the government lawyers rule. I do think the public defender's office are government lawyers the way that rule talks about them. The state public defender is a sub-agency created by statute. The state public defender is housed in the Iowa Department of Inspection and Appeals. It's like any other state agency.
So, so you would agree, like I'm reading the comment to 32 1.11 says, because of the special problems raised by imputation within a government agency, paragraph D does not impute the conflicts of a lawyer currently serving as an officer of the government to other associated government officers or employees, though ordinarily it will be prudent to screen such lawyers. So you think that applies here?
That's exactly right, Your Honor.
And your argument is that even though Mr. Smith seems to be equivocal on whether he's a government agent or government agency, his boss is back there. I know the governor appointed him, so that's your position, right?
That's right, Your Honor. The rule talks about special problems, and that's what we have here. Prosecutors and public defenders face different conflict problems than a private firm does. Of course, Mr. Smith and his colleagues don't get to pick their clients. On the state side, we have some discretion about what charges we bring, but certainly on appeal, the Attorney General doesn't get to pick cases. It would be a huge problem if every time someone in the Attorney General's office witnessed a crime, our entire office was disqualified. The same is true of a county attorney's office. And I think applying these special rules is especially important in a state that has a mix of rural and urban counties like Iowa. There are certainly places in Iowa where in the entire county there may be one or two experienced criminal defense attorneys. There's a lot of overlap between the victim and offender community. That's the language some of the social science research uses. In most prosecutions brought by the state, at least one witness, if it's a felony trial, will have some kind of criminal history. And in all likelihood, those persons will have been represented at some point by a unit within the state public defender's office. If we disqualify the public defender in every case where one of the state's witnesses was previously represented by them, we're going to disqualify the PD's office in more and more cases until probably the point where we're never going to see the public defender in a case. And that runs counter to public policy and certainly counter to the intent of the government lawyer's rule that's contained within the rules of professional conduct.
We haven't talked about is the interest of the defendant. This particular individual is facing a murder one charge, so a life sentence without parole if convicted as charged, and seems to want the services of the public defenders he has now as opposed to some folks with the juvenile public defender's office. Is that something we need to weigh into the mix?
I think it's relevant. One of the reasons this case is different from what we've seen in the past is that explicit waiver. And the district court here, I think, did a good job of getting that waiver on the record. We have a written document and we have a colloquy. I don't think there's any question that Mr. McKinley understands the choice that he's making. And there are good reasons he could make that choice. The public defender's office certainly has substantially more experience with homicide crimes than your average court-appointed attorney. He probably has a rapport with the two women from the public defender's office. There are good reasons he'd want to keep them, and that should weigh in here. That's why the states really framed this issue as being about the Sixth Amendment rather than the ethical rules. I think the rules are helpful. They help provide some guidance to our discussion. But what we need to focus on here is the Sixth Amendment. This is a criminal case. The rules of professional conduct don't get to trump the Constitution. Our core concern here has to be making sure we've protected the defendant's rights, and in turn, we protect the state's convictions obtained in the district court and the integrity of the process. To the extent we're going to look at the rules and find some guidance there, this court's already hit during Mr. Smith's argument the really problematic issues with the district court's interpretation of the rule. For example, most of the information that's the alleged conflict here is publicly available information. Rule 32 1.9 explicitly says that publicly available information, the fact of a felony conviction, can be offered without any kind of ethical problems. And similarly, Rule 31 1.9 talks about how the core focus in the analysis is whether any confidential information is possessed that can advance a client. And here we know there's no confidential information. The district court here should have deferred to the assessment that was made by the public defenders. And that's not a new or a foreign concept. The U.S. Supreme Court in Holloway and in Kyler said we should defer to the assessment made by trial counsel. They're a lot closer to the situation than we are, and it's their duty to come forward if they have a conflict. Here, the public defenders explicitly said the opposite.
How do we know there's no confidential information? How do we know that in the middle of the trial, something's gonna come up, and these public defenders' duty now is, well, I want those old files from those witnesses, and I may need them. How are we gonna know that's not gonna happen?
Well, I think we have to assume the public defenders aren't going to break the law. I think privilege applies to those former clients, and if they've been effectively screened out like they have here, the district court judge can certainly enter an order prohibiting them from accessing those former clients' files. And if the public defenders did so, they'd be in contempt of court. They'd likely be violating the rules of professional conduct.
But there may be stuff that's public and there may be stuff that's semi-public. And the semi-public stuff may be in the files or may be gained from the public domain. And how do we know that these lawyers got it semi-public rather than from the old files? I mean, you could talk to a lot of people and find a lot of things about people, and that stuff very well be in those files. I mean, I guess your answer is screening, and some order screening, and some enforcement of that order.
Yeah, I think it's a two-part analysis. First, screening. We make sure that they're not looking in the files, they're not able to look in the files. And second, we have to trust that the public defenders are telling the truth to the judge. If they're asked on the record and they make a professional statement, they're officers of the court just like the rest of us. We have to assume that they're telling the truth.
How far would your government rule go to court-appointed counsel who are paid by the public defender's office? I mean, there's a whole list of contract lawyers who are on the thing, on the list. Does the government screening rule apply to them too?
I don't think they're government employees. In fact, there's administrative rules that say that they're contractors, independent contractors, rather than employees. Employees are under the direction and control of a government entity in this case. The state public defender exercises control and dominion over his employees.
But they're not public employees in the sense of you, where you're directed by Mr. Miller or somebody else from the office to take a position and do it. And he or someone in your office controls what you do and how you do it. Although you probably have some independent judgment, I think a lot with General Miller. But, you know, he could come in and say, I want you to argue this, and you could talk to your faces blue, and you're going to argue this because that's what your boss is. That doesn't happen with the public defender, because the public defender's office cannot go in there and tell one of its attorneys, I want you to do this, this, and this way, and that way, because they have independent judgment because of the Constitution to represent those people. So how do you say that those government lawyers are sort of like you as a government lawyer?
I think they're probably similar to agency counsel. For example, the agency might take a position that has to be defended by a lawyer the lawyer doesn't agree with, or the independent judgment of the lawyer might reverse or change the decision of the agency. I think there are some issues where the state public defender does exercise dominion and control over his employees when they take policy positions. For example, cases that affect the state public defender system.
The agency tells the lawyer what to do because they're their boss, and we want you to argue this and defend this position. The public defender doesn't say, well, don't make this argument, or don't do that, and the public defenders are subject to ineffective assistance of counsel, which is independent, is their own actions, not the agency's actions. And I see a difference there, and you still haven't got me, so get me.
I think you're right, it's a tough question. We see a split in the decisions from different states. Justice Mansfield earlier mentioned the Connecticut decision, Anderson. We've seen courts grapple with this decision, but we have to weigh two things against each other. One is our question of problems interpreting the rules, what you suggest about independent judgment, and are these people really employees under the government rule? And the flip side is the special problems with conflicts of interest. I don't know how we get around the conflicts problem unless we rely on...
We adopt a new ABA rule, and this case is over. But we haven't adopted a new ABA rule, so we have to deal with our rules.
I think that's right, Your Honor. I think a better solution is to go to the screening rules that have been recognized by the ABA. But I think at least until we do that, a stopgap measure is to ground the analysis in the government employees prong. Certainly, a public defender is closer to a government employee than a retained attorney is, or an attorney that works in a firm is. And I do think there's a difference between a court-appointed attorney and a public defender. Part of the concern with the ethical rules is potential conflicts with how the lawyer is getting paid. A court-appointed attorney is submitting claims, but his practice is variable. He depends on the judge for appointments. He depends on other factors in the system to make sure people are coming to him for the private portion of his practice. Public defenders don't have that problem. Like I said, they don't get to choose their clients. They're salaried employees. Their payment and salary and benefits are fixed by statute, and they're more like a government employee in that sense, and that they're similar to employees in my office.
We look at a government employee, how you're paid. We look at a government employee, how you exercise the judgment as a lawyer. And I think they're very distinct. And I think that's how you have to look at it, not just because they're paid by the government.
I'm not sure that distinct.
I'm a government employee, but I hope I'm independent.
I suspect you are, Your Honor. In this case, if we look at the rule about government lawyers, there isn't any kind of magic test to apply. It talks about public officers and government employees. Under the code, the public defender's office contains public employees, and the state's position is the rule applies. I'd ask that this court remand with instructions and provide concrete guidance to resolve this problem.
Thank you. Mr. Smith?
May it please the court.
Mr. Smith, would you start with, I'd invite you to react to Mr. Buller's suggestion that we should disavow Watson. What's your view on that?
I think that for the issue that was presented in Watson, that is contemporaneous representation of a witness and a client in a current matter, that the trial court is going to be in a much better position to analyze upfront whether there's going to be a problem during the course of the trial. And so to the extent that the case before the court right now, McKinley, is not Watson, because it doesn't involve contemporaneous representation of a prosecution witness and a defendant in the same case, Watson may still have some value in sort of heading off what Mickens, I think, tells us is that this is sort of an after-the-fact analysis. We have to wait and see how the trial goes before we find out whether there's a problem. But my recollection is Mickens was co-defendants, which is even, I don't know, worse, but farther removed from the case that we have now than Watson was. And so I think the analysis doesn't have to go and wait for the result, because the rules of professional conduct don't indicate that this is going to ever be a problem. They're not substantially related matters. The attorneys have no confidential information that they could possibly use. And I think, I agree with Mr. Buller that if an attorney tells you that they are not going to look at the files and that they don't have this information, you have to take that at face value unless there's some really good reason to doubt that. And I don't think, we don't have that in this particular case. I do want to address just a moment, for a moment, the government lawyer thing. We're not like an assistant attorney general. Within our offices, the supervisor in the office may have some marginal direction that they can provide to the attorneys that work for them. But that's as far as it goes. Our attorneys represent their clients. They exercise independent judgment with regard to representing their clients. No one tells them what position they have to take in a case. And that includes, I think, to a certain extent, their clients. At least I know I've had clients who have suggested that I take a certain position in a case that I have declined to.
Which way does that cut? I mean, in a law firm, that isn't the way it works. I mean, in a law firm, there's a management committee and there are partners, and then there are partners. And if you're an associate and you're told to deliver a file to a partner, you're probably going to deliver that file. I mean, the independence that you described, I think, speaks in favor of applying 32-111 because the likelihood that one public defender is going to go and persuade another public defender to give her confidential information that she's ethically bound not to disclose would seem to be low.
Yes, I think the possibility that that would occur is very low, if non-existent in our case. But if the analogy is in the Attorney General's office, the Attorney General gets to decide what every one of his lawyers does or what position the state is going to take in any given case. That's not how the public defender works. And to that extent, we're not a government. We're paid by a government agency, but we operate independently of one another. For instance, the trial attorneys don't even tell the appellate attorneys what positions they may tell us what positions they think we should take, but we don't necessarily adopt those positions. I don't think you need to go there. It would be wonderful if you could come out with a rule that says we're just not going to impute anything in a public defender office, but I don't think you have to get that far in this particular case. I think it can be resolved. The matters that the witnesses were involved in are not the same. They're not substantially related to the current case. There is no conflict. Thank you.
Thank you. This case is now submitted, and we'll hear from the case of K. Decker versus Iowa State Board of Tax Review and Cable One.